Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Cambridge University Press, and it's on the interesting but sometimes vexed subject for some of jurisprudence, and the book is called The Legal Relation. It's this book here. It's got a subtitle, Legal Theory After Legal Positivism, and it's been written by Alexander Somek. Elizabeth and I had a chat about this book. It's part of the Cambridge Introductions to Philosophy and Law series, and our headline for the review is A New Look at the Leading Aspect of Modern Jurisprudence from Professor Somek. And that's exactly what you're getting with this book. Let's have a look at it first of all. Very nice picture on the front. There's the spine. It's a paperback, as you can see. Just a little bit of blurb on the back. As you can see, it's from Cambridge, and it's the Introductions series. The back of the book, it's just over 200 pages long. You've got a standard index at the back by page numbering, and then after that you've got, I'll show you the index first of all. You've actually got there's the index there. Then you've got the bibliography itself. All the usual suspects are there. Everybody you would think of, Joseph Raz, just looking at all of the names, Hobbes, all the way through. So very detailed bibliography, as to be expected. And then you've got the standard text. You can see it's structured like that. This is the epilogue at the back. There is a little bit of footnoting, not very much, very small amount of footnoting really, some subheads, you can see the footnoting there. We go to the front of the book, some quotes about the book. This is a substantive work. This is about actually the book itself, some of which I have used in the quotes in the review. Then you can see the Cambridge Introductions series there. Then you've got the front page there. And you can see, in fact, that Professor Somek is from the University of Vienna and the University of Iowa. So it's a mixture of universities. Then there's the blurb from Cambridge University Press. Then the basic layout of the book, contents section. And you can see the various chapter headings. And in fact, the quest for agency is the last main chapter. And you need to read that to get some idea of the themes that he develops. And if you read the preface, you will see from the preface what he's trying to set out, and I do explain that in the review. Then you start the introduction, the pursuit of theory. Now, for a lot of people, this would be a book they don't want to actually read, and there are a lot of reasons for that, because jurisprudence is not that popular a subject, and of course it's compulsory for many examination schools. This is what we say, though, because I've taught jurisprudence and I'm aware of the problems. It's always useful to see a new book which might just help students understand the complexities of jurisprudence and legal theory. The subject remains disliked by so many undergraduates as they see it as political and difficult to understand, with all the theorems and the names of leading jurisprudents unknown outside the world of philosophy and law. The strange concepts, for instance, of Hart and Dworkin, for example. So, what is this one about? Professor Somek states that, quote, legal theory ought to explain why and how the law matters to our lives, whilst admitting that there is an element of Marxist critique of law. He also says that new beginnings is needed. A new beginning is needed. But where would one go when both legal and positivism and natural law theory drop out of the picture? Step forward then the name of Alexander Somek. He bases his work on a return to the broader theoretical perspective from which modern legal positivism originated in the early work of Hans Kelsen, namely what he calls constructivism. So you've got another ism coming along. And that's one of the problems with jurisprudence, but get over it, because it's really a very interesting look at where we are with the theory of law. Now, this seminal work on what he calls the legal relation does not adopt any particular thinker. In other words, any particular person. Somek covers legal theory after legal positivism with a most realistic overview of what we mean by a system of norms. And of course, anybody who's understood Kelson will see where he's actually moving the whole of the issue forward. And there are 6 short chapters in the work in total, with an introduction and an epilogue in under 200 readable pages. And the author does remain faithful to what he calls the original constructivist ethos of modern legal positivism, and that's exactly what you're getting here. And I did think that the book was certainly well worth a read. It's not that difficult to read, but it's well worth reading once you've actually got into the subject. Don't read it right at the beginning, but read it once you've done a reasonable amount of study of jurisprudence. Provocatively, Somek posits the old question, what is law? He replies with this comment, which is in the throughout the book, in the blurb and everywhere else. The usual answer is that the law is a system of norms. But this answer gives us, at best, half of the story. The law is a way of relating to one another. And he goes on to compound his theory, saying, we do not do this as lovers or friends, and not as people who are interested in obtaining guidance from moral insight. So you've got some idea of the level at which he's adopting his particular theory, which is, as I say, is called the legal relation. One important point I think we should bear in note is that Somek says that it is that in a legal context we are cast as character masks, and that's a Marxist point of view. For example, as buyer and seller, or landlord and tenant. Now, I don't want to get into any of this, but you will know master and servant and all the other problems when you have this sort of labelling. I'm not even getting into labelling theory, but you can see immediately some of the problems. And the conclusion that develops is that we expect to have our claims respected simply because the law has given us rights. That, of course, being a bit of a problem when it comes to the interpretation by some of the Human Rights Act. And I'm not going to go, obviously, down that particular controversial route, but I think it's important to bear in mind about the existence of rights. And, of course, we found that the emphasis on Marx as a jurisprudent to be quite helpful with the resurgence of this man's frightening legacy on the development of human society in so many countries as such an obvious mechanism to create dictatorships. And therefore, remember one important point about Marx, and that he had a very limited approach to what we describe as law and jurisprudence, because his main approach was, of course, economic and political. Somek concludes that we do not want to give any other reason for our behaviour than the fact that we have a legal right. Backing rights up with coercive threats indicates that we are willing to accept legal obligations unwillingly. This book, he therefore says, offers a conceptual reconstruction of the legal relation on the basis of a critique of legal positivism. That is where he's coming from, and that's really the value of the book to you as an undergraduate. So let me conclude by saying that the book was published on the 30th of November 2017 by Cambridge University Press, and we suggest it will be a huge benefit to those students who of jurisprudence who are seeking a higher level of research for their final degree classification. In other words, read the book, and that will give you a certain amount of additional understanding of the subject matter, and probably more marks. I'd like to thank Professor Somek very much indeed for the book. We'll have a look at it again. There it is. It's a very interesting book. It got my attention when I saw it, and I thought, well, it's a book I will read and review. There's the side and there's the back of it. Just opening it in the middle. Legal science and the common law, for instance. You've got a very interesting comparison there. Again, he goes straight into constructivism again. And I have to say, when I was originally reading jurisprudence, we didn't put very much emphasis in that particular area. There was clearly the row between positivism and natural law, and that was actually enough in many ways to develop the debate towards both Hart and Dworkin. But things have moved ahead in the basically the last 40 odd years since I've been involved in this area of law. Anyway, a big thank you to everybody concerned for the book. It's a good read, and it will give you a first, I think, if you understand it fully. No promises though. Good luck with your exams. Bye bye.